version of that here at that transcript, but I want to get your input before making a decision.
Judge, we intended to do that as well. We haven't stipulated, we haven't come together to stipulate on a version of that transcript that should be redacted. We certainly can do that, and we're happy to do that.
Thank you, Mr. McBride.
We will meet and confer with Mr. McBride and his colleagues on that.
All right. How much time is needed by the parties?
2 weeks.
That's fine. A couple weeks.
All right. A couple of weeks, and then we can address that. Next, I want to turn to address media coverage and place on the record the potential consequences of any willful violation of the court's December 23rd, 2025 standing decorum order. Under Utah Code Section 78B-6-310, if the court finds a person guilty of contempt, the court may impose a fine of up to $1,000, order incarceration in the county jail for up to 30 days, or both. Any alleged violation will be carefully evaluated, and the court will impose only those sanctions which are appropriate and proportional under the circumstances. The court will make specific findings on the record before imposing any sanction. In addition, the court may impose the following remedial measures if warranted. First, immediate suspension of video transmission of the hearing, with proceedings continuing on audio-only basis for the proceeding where the violation occurred, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of court proceedings for the hearing in which the violation occurred from providing pool camera operator services in this matter, where the court determines that such a measure is required to ensure compliance with the standing decorum order and to protect the rights of the parties. Counsel will be allowed to provide their input before the court makes any final determination regarding sanctions. I want to emphasize that these measures are not intended to have a chilling effect on open and transparent courts or on responsible news gathering, and the court remains fully committed to the presumption of open proceedings under applicable rules. Rather, they're intended to protect the constitutional rights of all parties while preserving the integrity, openness, and fairness of these proceedings. Third, at this time I wish to address the camera operator. Mr. Uhlberg, if you wouldn't mind coming forward and standing at the lectern. And could you state your name for the record?
John Uhlberg.
Thank you, Mr. Uhlberg. It's not my intention to cause you any embarrassment or discomfort. I simply want to ensure that the guidelines for today's proceedings are clear. Mr. Uhlberg, during today's hearing, what is your primary role?
To provide video coverage of the proceedings for the public.
All right. Have you read the December 23rd, 2025 standing decorum order?
Yes, sir.
Do you understand the guidelines as they relate to your responsibilities today?
I do.
Do you need any additional time to review the December 23rd, 2025 standing decorum order, or any time to reposition the camera to ensure full compliance with those guidelines?
Do I need more time? I'm sorry, was that the question?
Do you need more time to review the decorum order? And I'll pause there because that was a compound question. Sorry about that.
No, I've read it, I fully understand it, I'm good to go.
All right, to the second part, do you need any additional time to reposition the camera to ensure full compliance with those guidelines?
No, I think we're in a good position now.
All right. Mr. Uhlberg, do you anticipate any difficulties complying with the December 23rd, 2025 standing decorum order?
I do not anticipate any problems.
All right, and is there anything that the court can clarify to assist you?
No, I think we're good to go, sir.
All right, thank you, Mr. Uhlberg.
Thank you.
Before I let you go, I'll turn to counsel based off the questions asked. Turn to you if you have any input or questions.
Nothing from the state.
Thank you.
No, Your Honor.
All right. All right. And the court, I appreciate your cooperation, and it's my hope that we all do our very best today together.
Absolutely. Thank you.
And finally, before we turn to the issue, the motion before the court, to the state, could you please provide a brief update on the status of discovery disclosure?
Yes, Your Honor. I don't have the percentage of materials that we have that have been disclosed, but I think we're above 90% at this point. There still is discovery coming in. There are reports and so forth coming in from various entities. So I think we're moving expeditiously towards completing at least this initial batch of discovery. Of course, discovery will be ongoing probably for the duration of the proceeding, but we have provided nearly all of what we have to date.
All right. And to defense, any input?
Not at this time, Your Honor.
Thank you, Ms. Nestor. All right. Thank you, counsel, for your patience as the court covered those preliminary issues. Let's turn to the defense's motion to disqualify the Utah County Attorney's Office. Ms. Nestor, Mr. Novak.
That's fine, Your Honor. That's okay. We actually have some preliminary things we want to discuss with respect to the posture of this motion. And I also think at some point the court needs to decide at what stage the hearing on this motion remains open and becomes closed. So I'm going to bear that in mind in terms of my preliminary statements, if I may. When we filed this motion to disqualify, and when I say we, I mean Mr. Robinson's counsel, we fully expected that what the Utah County attorneys would do is refer the motion to the Attorney General's office so that the Utah County attorneys are not in the position of representing their own interests as potentially conflicted attorneys in a potentially conflicted office, and representing the state's interest in the prosecution. We heard informally from the state's attorneys that they were preparing a response and when it would be provided. And then what we received, and again, I'm bearing in mind that we're in an open hearing at the moment, was a brief where I'm going to say the unsworn representations of two attorneys from that office are basically integrated into points and authorities. We don't have affidavits from Mr. Gray or from the other attorney. We have argument. We noted in our reply that we were surprised, that's in footnote 2 at page 4, that the Utah County attorneys were representing themselves in connection with a motion alleging that they have a conflict of interest and that the state was not being represented through the Attorney General's office. We did some further research on this, and you know, we have some case law that we can provide the court. I suspect that the court is very familiar with the fact, just from its own experience, that in appropriate circumstances, the Attorney General's office can either, one, represent the state in what was a county prosecution with respect to a disqualification motion so that the boundaries are clear, or if there's an ultimate finding or conclusion that there's a conflict of interest, take over the prosecution or assign it to another county. So we're very concerned that we're getting off on the wrong foot, if I can use that metaphor, because we have officers of the court who are both representing their own interests in continuing to be the prosecutors in this case and representing the state in a situation where there should be what I would call at least temporarily conflict counsel. I'm not sure that's the term the Attorney General uses, representing the state's interests. There's a Supreme Court decision which is called State v. Jimenez, Jimenez, which I can provide a citation for. There are subsequent cases, but it's pretty clear that this is the type of a case. I'm not saying that Jimenez compels that action, but it seems to me to strongly suggest that where there is a showing, I'm not sure what the threshold showing is. I don't want to say it's a prima facie showing or a reasonable concern, but where there's a showing that there very well may be a conflict of interest that hasn't been handled by a particular state attorney's, county attorney's office, that what's in the interests of the litigation, of the public, of the parties, is for the Attorney General to step in. And the citation for State v. Jimenez, if I may, is 588 P. 2nd 707. Of course, I can provide the court with the Utah citation as well. This court actually has the authority under that case, State v. Jimenez, to direct the Attorney General to step in, not for the entire case at this stage, that's not what we're saying is necessary, because that requires a finding of a conflict of interest, but to step in or to designate somebody to step in for the purposes of litigating that motion.
Okay.
And so we're very concerned that even going forward with an evidentiary hearing where members of the Utah County Attorney's Office are both litigating as representatives of the state in a prosecution and essentially defending their own propriety of proceeding in this prosecution is problematic. As far as being prepared, we're of course prepared to go forward with an evidentiary hearing, but we think that it's improvident, and we think that what the court should do, if the Utah County attorneys have not or don't, if given the opportunity, do this on their own, is that the court should designate the Attorney General's office for the purpose of litigating this motion. The court might ask, hypothetically, the question, has the Utah County Attorney's Office conferred with the Attorney General about this particular question? And we are not in the dark, because as Ms. Nestor will tell the court, as an officer of the court, she's spoken with the Attorney General's office, and they have not been consulted about this. Okay? So this is a motion to disqualify a county attorney's office based on what we believe is a material, significant conflict of interest that it's clear they haven't even tried to address by way of a screening, which of course is a term of art, because their position is no screening was necessary. We're not even here to discuss whether the way in which a particular attorney was screened off was adequate. Their position, as their own advocates, is we've already decided no screening is necessary. So what we've been told by the Attorney General's office, Ms. Nestor can represent to the court exactly what she was told, but basically that there has not been consultation. And while that is Mr. Gray's prerogative, we think it's wrong, and we think that this court needs to exercise its authority to intervene and say, in this case, for this kind of a motion, the court needs to hear from a representative of the state who does not even appear to have a conflict of interest. So that's our preliminary statement about these issues. And again, I hope I've avoided saying anything that should have been said in a closed hearing. I think I was pretty good about that. So that's where we are before we even get into the litigation of it. And I don't want to be formalistic, and I'm certainly not trying to be confrontational, but I think actually what we think the court should do is the court should strike the Utah County Attorney's response to our motion and direct the Attorney General to take up the responsibility for responding to our motion in whichever way clearly non-conflicted attorneys representing the state think they should, how it should be responded to. And if I've muddled, I always say this, Your Honor, if I've muddled anything or confused anything, please say so, and I'll try to clarify.
Thank you. I do have some questions for you as it relates to this. I wish to consider all the authority that you wish to cite to. I mean, obviously, you came into this hearing knowing that this is something you're going to present, and this court wants to be efficient with time, but thorough.
Yes.
And not jumping to conclusions. Can you give me all the authority that you wish for me to consider in considering your request today?
Yes, and I think what we could also do, which maybe would be more helpful to the court, is that we could file a short brief on this particular issue, because I will acknowledge that while we were surprised that the brief was filed by the same lawyers who are alleged to have this conflict of interest, it took us a little bit of time and we wanted to get that filed in time for today's hearing because the court had set the hearing. It took us a little bit of time to think through these issues. So there are Utah authorities, there are authorities from other jurisdictions, there are also ABA guidelines on the prosecutorial function, which we think strongly suggest that there should have been what I'll just call a referral to the Attorney General's office for this particular motion. I can stand here and I can give the court case names and numbers and sections from the ABA standards, but it was not our goal to, of course, put the court on the spot and require the court to, like, go back into chambers, think about it for, some pressured period of time and come back out and make a decision. So if it would benefit the court for us to file something, and I don't mean in a month, I mean very soon, so that the court has thoughtfully presented points and authorities, we're happy to do that. As far as I know, the only people who've traveled out of town for this hearing are Mr. Burt and myself. So I'm thinking about the convenience of witnesses and the court and counsel. It's important that we do this in a way where the court has the opportunity to make a thoughtful, reasoned decision, as Your Honor always says. So that would be our proposal, is that if the court is open to receiving authorities, that we recess this hearing for, whatever meets the court's schedule, whether it's a week or 2 weeks or a few days, and we can provide the court with something, and we'll come back. But we do think this is a serious issue, because I think the question of who litigates this issue on behalf of the state is in itself wrapped up in this conflict. And we want everybody to get this right.
Thank you.
Once.
My question for you is, knowing this, why didn't you file a motion prior to today's hearing, knowing that the court would be in this position based off of your request, to prepare the court, prepare opposing parties, and to be efficient in our use of time? I'm trying to understand. I understand what you're saying, and I understand that things evolve, but I'm trying to understand why that wasn't filed in advance of the hearing to put the court on notice at the very minimum, and just to allow the court to do what the court does.
I hear what the court's saying, and I think we can take responsibility for not sufficiently presenting the authorities that we think compel what I've just suggested should happen. We noted in our reply brief that the county attorney should not be representing themselves. And that's probably an inadequate message to the court. But we did file a motion to disqualify. And inherent in a motion to disqualify based on the conflict of interest, we anticipated would be that the state attorneys would seek representation from a clearly non-conflicted, appropriate prosecutorial authority, which, as I've done further research, and Mr. Byrd and Ms. Visser and Ms. Nestor and I have all done further research literally up until earlier this morning, we think it's pretty clear that this court has the authority to make that, I'm going to call it a referral. I think it's an order referring it to the Attorney General if the Utah County attorneys choose not to do so. And the additional information, which we did receive today, I'll just tell you that, was that there had not been any communication between the county attorneys and the Attorney General's office concerning this issue. So I'll fall on my sword. If the court thinks I should be sanctioned for not bringing this up sooner, I hear the court, but we are we're juggling many aspects of this case all at the same time, some of which the court is aware of, some of which the court probably is not aware of, but the court can imagine.
No, and I appreciate that. It's not the intent to sanction you. I understand that issues come up, and there's a lot going on, and so the court appreciates your candor and representation today. So these items can evolve, and so the court is not finding fault with you. It's just hoping that, as it requires a lot of time and resources for you and for fellow attorneys and for the opposing party and for other parties, we just might want to make sure we make the best use of our time when we're together.
I hear everything the court is saying. I take it to heart. I understand what the court's saying, and we are cognizant of the time that the court devotes to preparation for these hearings. So that's all I can really say.
That's right. And also for Mr. Robinson himself and the victim representative, Ms. Kirk, as well. We just want to do our best, and I understand, and I'm not finding fault with you, sir, or your team. We've all been in court. We all know what happened, so I understand. I'll turn to the state. Oh, and I'm sorry. Is there anything further that you wish to represent?
No, I could provide the court with more citations, but I'm just wondering if that's really the best way to give the court a list of verbal citations. I think with all consideration for, and we probably have, with all consideration for the fact that the court wants to be thorough and careful, and we do as well. We don't want to shoot from the hip, but I think that we just decided that this was something that we needed to bring to the court's attention in a much more fulsome way once we understood not only the way this was developing, but frankly the way the Utah Supreme Court, the ABA guidelines, courts of appeals subsequent to State v. Jimenez, and the information that we received today from the Attorney General's office, which isn't a secret. It's just we had a conversation and we learned that there hadn't been any consultation. If there had been consultation and the Attorney General had said, no, we think you're good to go, then that would be different. And that's what we learned this morning.
All right. Well, I'll go ahead and take those authorities right now. If you'd like to list them, the court is ready.
So the second one would be State v. Robertson, and that is also a Utah case, 886 P. 2nd 85. There's the ABA prosecution standards. I would refer the court to section 3.1.7 and 3.2.5. And those are, I think, the places to start.
Is there any Utah rule on point that addresses this issue?
So the case of State v. Jimenez, which I referred to, which is the Supreme Court, does actually cite a statute.
Okay. Anything further that you wish for this court to consider at this point in the proceeding as it relates to this issue?
No, and depending upon the statements of counsel, we may have some response if the court permits it.
Of course.
All right.
Thank you. Turning to the state, Mr. Gray.
Your Honor, I'm not sure why this is coming before us today. If it was such a surprise to them, more than a week ago. I don't know why they wouldn't at least notify the court. I too represent the state. I'm an elected official, constitutionally elected to represent the state. Where does this end? I don't know these cases. I'm very interested to see whether or not they refer to trials. I know that the Utah Attorney General's office, they've done the same thing that we have in Rule 11 motions, where one counsel on the team examines their boss, in fact, on the matter. So I just think this is ambush and another stalling tactic to delay these proceedings. There's no reason that they could not have at least filed the motion and asked for time to brief it. And where does it end? Do we get to respond to their motion to have the Attorney General's office respond, or does the Attorney General's office have to respond to that one too? I'm not, well, anyway, I've stated my, it should have been done far earlier if that was their case, if that was their claim. And if I could just turn the time over to Ryan in case he has something else.
Thank you, Mr. Gray.
Yeah, I
Mr.
do.
McBride.
And excuse me, this is, we're tag teaming this somewhat because it's a surprise to us as it is to the court. But in the 5 minutes I've had to read Robertson and Jimenez, which could have been provided to me before this hearing, it looks like those cases don't stand for conflict of interest cases. They're actually, does the Attorney General's office have authority to prosecute cases that occur within a prosecution district or county attorney's jurisdiction? And the answer is yes. It's not about taking conflicts from the few minutes I've had to read those cases. I do want to state this is, of course, the first time this has been raised to us. The defense has known that we were going to respond to this motion for some time. We requested an extension for our filing deadline back in December. The defense agreed to that extension. Our reply was filed January 5th. The defendant's reply was filed thereafter. And in that reply, the tone of that reply is mentions that they thought that perhaps a special prosecutor would be appointed to handle the conflict case, but in the alternative says we'll be able to, we want to subpoena witnesses to establish the facts that are laid out in the state's opposition motion or memorandum. And that was what we understood was going to happen today. You have a family member of a prosecutor who has been subpoenaed. An affidavit has been supplied to the court. We believe that affidavit is adequate, but it wasn't adequate from the defense perspective, so they subpoenaed that person. Prosecutors have been subpoenaed for today's hearing. We have 2 investigators that have been subpoenaed for today's hearing. And we are ready to go, Your Honor. I think that the motion or the request the defense has made assumes that a conflict does exist and that there's an inability of the party who has been accused of a conflict to defend themselves. And I just don't think that that's true. If there is a conflict, which is the question that this court is to decide, the case will be referred. Until that conflict has been established, the case is properly in the jurisdiction that has statutory authority over that offense. And until that conflict has been established, the Utah County Attorney's Office has this case and can defend its involvement in this case. I got just a moment to review my notes and see if there's other points we want to make on this.
Of course.
There is one other point I wanted to make, which is the idea that the case would be referred, that alleging a conflict would cause a special prosecutor to be appointed. That really assumes that there is a conflict, and until that conflict has been established, there is no duty for the case to be referred to another jurisdiction or another special prosecutor to handle. And it raises some of the issues that have been brought up in some of the case law regarding creating or alleging conflicts. There's a lot of case law that talks about how it can be a tactic to try and remove cases from one prosecutor's authority to find a more lenient prosecutor, find a more favorable prosecuting authority that's not going to seek, for example, in this case, the death penalty. And there's a lot of case law that talks about you can't call opposing counsel as a witness in a case unless they're absolutely necessary. And the reason is because it can be a forum shopping effort. And we're concerned with that same kind of motivation or tactic that could be used in this case or other cases like it. Anytime you, as opposing counsel, you don't like the offer you're getting, the way the prosecution is being handled, you allege a conflict of interest, and all of a sudden the county attorney's office has to spend $10,000 to hire a special prosecutor just to handle that one issue, regardless of whether or not it's supported or whether or not a conflict exists. That's a concern we have. Your Honor, we're ready to go forward today. We think the evidence that will be presented today will illuminate the issues adequate that Your Honor can make a decision about whether or not a conflict exists, and we don't need to delay this proceeding any further. We're confident the court will see the facts as they are and be able to make that determination.
Mr. McBride, so the motion has been made by defense to continue this hearing to allow the filing of a motion addressing more fully this issue. And to that request, what is the state's reply?
We object to that motion to continue or to strike. We ask the court to go forward today. We think the motion is untimely. The court has, or the prosecution has subpoenaed witnesses, and every delay that happens, the witnesses that we have now family members of the prosecution being subpoenaed. These people are ready to move forward and get this out of the way. The longer we delay this, the more anxiety that this procedure has.
All right. Thank you, Mr. McBride. To defense, any response?
Yes, John, thank you. First, I want to say this is not about seeking a lenient prosecutor. This is not about tactics at all. And it was actually the county attorney's office who informed us back in October that there was a family member of a prosecutor who was present at Utah Valley University at the Charlie Kirk rally and experienced and witnessed certain things. We didn't make this up out of whole cloth. We didn't grab onto some piece of discovery and say, a wedge, a tactic. The Utah County Attorney's Office informed us in late October that we needed to know about this, and we informed them, fine, that's your position, it's not a conflict of interest. We think it is, and we intend to litigate it. So it's not a tactic, it's not something that we've made up out of whole cloth because, like I said, we found a needle in a haystack. It's something that they properly brought to our attention, but we firmly believe that the law supports the conclusion that that particular prosecutor should have been screened off. There's good case law on screening, which we did fully cite in our briefs in a timely way, and there was no effort to screen off that prosecutor, and that has now created a problem for the whole office. That is not made up out of whole cloth, and like I said, it's not about tactics or lenience or delay. This isn't delaying anything, at least on our part. The other thing that I want to point out is to say that until this court decides there's a conflict of interest, somebody else shouldn't be handling this issue is circular. Because by that point in time, the court would have already allowed the conflicted attorneys to represent the state in a hearing on their potential conflict. So I actually think the way you avoid that circular argument and the sort of harm that arises if the court were to find that there is a conflict is to at least temporarily have the Attorney General's office handle this. Yes, Mr. Gray is an elected official, but that doesn't mean that his office doesn't have a conflict of interest. Conflict of interests arise. A judicial officer decides to become a prosecutor. A prosecutor decides to become a judicial officer. That's actually where most of the case law comes from, as Your Honor knows. A defense attorney changes careers and becomes a prosecutor. There has to be a screening. The case law is very clear that the screening has to be adequate. There's been no screening here because Mr. Gray decided we don't think there's a conflict of interest. And what we're saying is it's not a needle in a haystack. It's not a tactic. It's not a fiction. It's not a, you know, a thin reed. The evidence that the court has suggests, number one, that there's a very good possibility that as a legal matter there's a conflict of interest. That's why we need to have an evidentiary hearing, because the court doesn't have all the facts. And number two, that the Utah County Attorney's Office, because they decided early on, without consulting with anybody, that they didn't have a conflict of interest, didn't put any screening mechanisms in place. And so I understand that they want to defend the decisions that they've made. But the question is, shouldn't the state be represented by somebody else in the course of this court resolving whether those decisions were right? Because to quote the law and to quote the ethics, the Utah County Attorney's Office is now serving two masters. I don't like that word, but that's the word in the doctrine. They're representing themselves and they're representing the state of Utah. And that's why the Attorney General or somebody else designated by the Attorney General should be representing them in this matter. And I do want to say one more thing, if I may, Your Honor, and I appreciate the court's patience. I think that the way we raise this issue in our reply brief is not as accommodating to just letting it go as counsel suggests. What we said is we asked the question is whether it is even appropriate for the UCAO to litigate this issue on its own behalf. While the UCAO may have provided this court with the information that it has deemed relevant to this issue, the scope of the disclosures and litigation of this motion should have been assigned to another state agency, such as the Attorney General. We didn't suggest that this court should appoint a special prosecutor for all purposes, or that the filing of this motion means that the Utah County Attorney's Office is automatically disqualified from the litigation. That's the point of the motion, is whether they had a conflict of interest, and if they did, whether they handled it. And it's our position correctly, and it's our position that the answer is yes and no. So I understand there are witnesses here, people are ready to go. We think that the court should either accept briefing or agree with us that the referral is appropriate. And I want to cite, if I may, the citation by the Supreme Court in Jimenez. So this is 588 P. 2nd. It's 707, but this is at 708. This is the statute quoted by the Supreme Court. If at any time after investigation by and a finding and a recommendation from the district judge involved that the county attorney in any county is unable to satisfactorily and adequately perform his duties in prosecuting a criminal case without additional legal assistance, the Attorney General shall provide such assistance. That's very broad. What that means in this case is it's inappropriate for the Utah County Attorney's Office to represent itself when it is also representing the state. and that for this motion, this court has the discretion, we would say, respectfully, the obligation to designate the Attorney General to represent the state, the people of the state of Utah, in this motion. And depending upon how the court rules on the motion, then we have to see what happens next.
So is it your position that the court has discretion to make that decision?
I think that the court has the discretion to say to the Utah County attorneys, you shouldn't be representing yourself in this case at this stage as to this motion only. Continue to do what you do while this motion is pending, and we will resolve this motion. I am not suggesting that they should stop the work that Mr. McBride talked about preparing discovery, having their agents interview witnesses. We want to get this motion resolved in a timely way. It is not a stalling tactic. But I'm not saying, let me be very careful because I don't want to misinterpret the court's question. I'm not saying that whatever this court decides is the right decision because the court has discretion. We believe that the law requires that the county attorney's office be represented by somebody else for this motion. What I'm saying is the legislature gave the court the authority to compel that when the state attorney and the attorney general haven't done anything about that yet. I'm not saying that the court, I mean, I don't know what the standard of review on appeal would be, so I'm not just saying it's an abuse of discretion standard. What I'm saying is the legislature gave this court the authority to direct, refer to the attorney general representation in a criminal case where there's a showing of a potential conflict of interest. And I've been a criminal litigator, although on this side for a long time, so I understand what counsel's talking about is sometimes defendants come up with questionable grounds and move to disqualify. And I don't think that that's a finding that the court can make in this case. It was actually, as I said before, the Utah County attorneys who were concerned about this enough that they brought it to our attention. We have profound disagreements about the significance of the conflict and the way it was handled. Okay? And otherwise, I think I would be repeating myself if I said anything more without answering a direct question.
All right, I just have a brief question. Do you have your witnesses here today?
All the witnesses are here. We have no problem as a pragmatic issue going forward. Our witnesses are the subpoenas that we served, which were filed with the court. So to be clear, I don't think the court is inferring this. We're not unable to proceed if that was the court's conclusion. We are prepared, and the witnesses are here. I'm just saying we think that it would be improvident and it could result in errors of law, and it could result in problems down the road.
Thank you. Do you need any additional time in regards to your argument to continue this hearing based off the citations you've provided, the authorities you've provided the court?
1 second. No, thank you.
All right, thank you. What this court intends to do is, this is an important issue, and I realize the totality of what's been presented. And my question in regards to your witnesses, it was informatory. I just wanted to see if depending on what the court rules, if the parties, I don't want to disadvantage either party in that. So this is an important issue, and this court wishes to take a brief recess. I want to look at what's been provided and make see where the court needs to go. I want to inform myself, take a moment to look at it, and as opposed to just making a snap decision and taking into consideration all parties and the constitutional rights of all parties as well. With that, we will be in a brief recess. I always hesitate to give the time because
We'll be
sometimes I appreciate you being here. Court is in a brief recess. Thank you.
All rise.
are important, and the court wanted to take the necessary time to examine what has been presented and make a decision on how we move forward today. And the defense's argument, and the defense relying upon Jimenez and Robertson cases, if there is a showing of conflict of interest under Rule 1.7, then the court should exercise its discretion and require the Utah Attorney General's office to stand in for the Utah County Attorney's Office. Mr. Novak conceded that there has to be a very good possibility of a conflict or showing of a conflict. No authority was given to the standard of proof necessary to satisfy that showing. This court wishes to address the issue of the showing of conflict of interest under Rule 1.7. And with regards to the first question, whether the prosecutor has a conflict of interest under Rule 1.7, the defendant asserts the following facts, and I'm drawing from the motion itself and reading from it. One of the prosecutors on the case has a family member who, along with approximately 3,000 others, attending Turning Point USA at UVU on the day Charlie Kirk was shot and killed. The family member texted the prosecutor almost contemporaneously. We'll pretend I said that word right. With the event, and shared that they had heard the gunshot and that they had run with the crowd, and other observations, feelings, and reactions. Thereafter, the prosecutor went to UVU and investigated how far away his family member was to the shooting. The family member had left a backpack when they fled. The prosecutor determined that the family member was approximately 85 feet away from Charlie Kirk when he was shot. In my view, those are the alleged facts that the court must consider to answer the first question. Does the prosecutor, by virtue of his relationship with a family member who witnessed the shooting, have a conflict of interest under Rule 1.7? And turning to that, just looking at my notes, I appreciate your patience. And so turning to defense, if I accept the facts as you have alleged in your motion as true, is there any reason to call witnesses to answer the first question before the court? And before you answer that, I understand that there are other relevant facts that pertain to the effect of the alleged conflict. Those facts would include whether the prosecutor was properly screened from the case, what conversations he had with other prosecutors, and whether the family member's experience impacted the state's decision to seek the death penalty. It is the defense position, as I understand it, that those facts may need to be explored through witness testimony. But if we're just talking about the first question, whether the prosecutor has a conflict of interest under Rule 1.7, is there a need to call witnesses?
Yes, Your Honor. I understand that the court is trying to get to the threshold question that we have put before it with respect to who should be representing the Utah County Attorney's Office in this motion. But the answer to the court's question is yes, because it's not just the mere transactional event that that the offspring witnessed the shooting. It is the evidentiary development will get at, and again, we were only provided with an affidavit, which was very, if I may, narrowly drawn, at communications that happened after that between that offspring and their parent, between that offspring and other family members that may have been communicated to the parent, communications between the parent and other people in the office, impact. Okay, so now I'm going to just say, if I had found out that my child was at an incident where somebody was shot and killed, I would have an incredibly strong emotional reaction, even if they were safe. Okay, so give me a second, okay? There was a horrible shooting incident at Brown University a few weeks ago. And I have a child who lives within 20 miles of there who was in Providence that day. And everybody in our family was really freaked out until we knew that they were safe. And then even when we knew they were safe, the question was, what did you see? Did it affect you? Turned out everybody's fine. But it's not just, oh, I was there. Right? And my family member didn't witness a shooting. Wasn't in a crowd with 3,000 people who all had to run and take cover in case there were more shots fired, in case there were some other harm that occurred. Okay? So it's not just the fact that this person was 85 feet away from Mr. Kirk. It's that begins to that scratches the surface, if I may, of the totality of the circumstances, which we think created a conflict of interest. So the answer is yes, and that's why both the parent and the offspring are here and are under subpoena and agreed to be here and agreed to testify. Obviously, it's the court's proceeding, but nobody's moved to quash, and I think it's obvious that that's because we need further factual development. And our reply brief, if it did anything, it communicated to the court the case law, which shows that this is a fact-intensive inquiry and that affidavits are required. And here we don't have affidavits from the parent or from Mr. Gray. We have argument in a brief. But we also believe that testimony from the offspring is necessary, and they're here, and they agreed to be here. And they agreed that Ms. Visser could sign an acknowledgement of service of a subpoena. So the very, very long answer to the court's question is yes, definitely. We need to have an evidentiary hearing.
But isn't the defense required to make the threshold showing from the facts that you're asserting? Isn't that where we begin? Not necessarily the state's response, but don't you have a responsibility to show that you've made a threshold showing of what you're asserting would rise to what you're asserting in your motion?
So the state, so the Utah County attorneys informed us that this offspring was present in a crowd, was caught up in the ensuing chaos, heard a shot fired, had to leave their belongings behind, witnessed the trauma of other people. We can't really get beyond that without fact development. And if what the court is saying, hypothetically, is I want you to go sit down and interview people, that's one thing. But if the court's saying that we somehow should have more information than the county has given us, we can't do that without evidentiary development. Okay? We have questions about whether there were more non-recorded communications that we haven't been told about. I think we have a good faith, and the court could imagine that a family would talk about such an incident, and it wouldn't just be the text messages that the court has in the exhibit. And I don't purport to say anybody should run their family the way my family operates. I'm just talking about what I think would be natural, which is families talk about these things because we want to take care of our kids, and we want to make sure they're okay. And then we need to make sure that our responsibilities to the public and to justice aren't impacted by our personal experiences. And I think that we can only get at that, Your Honor, through evidentiary development.
All right.
And that's why, and I think that the state would agree with that, because that's why they provided the court with some affidavits and some fact in the course of argument. So I think that it needs to be fully developed through the very limited number of witnesses that are present.
I understand. Let me turn to the state. What's the state's position?
So I want to make sure I'm understanding your question. The question is, there's two layers here, right? The first layer is, when an alleged conflict arises, does the in this case, the county attorney's office, have to conflict the handling of that allegation to another, special prosecutor, attorney general's office, right? Your question is, doesn't the defense have to make an initial showing before that first conflict has, or occurs that requires that delegation?
Yes.
Okay. My answer is yes. I mean, otherwise we have to have a hearing to determine if another entity has to handle the substantive issue, and then you have to have another hearing to determine if there actually is a conflict. I think there has to be at first a showing that there is, a basis for a conflict. Otherwise, someone can come in and say, I think there's a conflict without any evidence whatsoever, or not evidence that's credible. I think, and for that reason, I think the court should be able to make this threshold showing based on the affidavit, right? The affidavit and the facts have been proffered. I think there's enough there for you to say, yes, the county attorney's office can handle this motion on its own, or no, this motion needs to go to the attorney general's office, whoever else, to handle the substantive issue of whether or not there's a conflict. I mean, I want to be clear. I don't believe under any of those circumstances that the issue needs to be conflicted out. I believe that until a conflict has been found, the county attorney's office or whatever entity has been accused of a conflict can litigate that issue without litigating that issue.
All right.
Did I make myself clear?
I appreciate that, Mr. McBride. A follow-up question in regards, they're proposing calling witnesses to make that threshold showing. What is the state's position?
No, I mean, my position is no. I think witnesses should be called one time in this case, and that should be to determine whether or not there's a conflict, not to determine whether or not the issue of whether or not there's a conflict should be conflicted.
Okay. I think there may have been a little bit of confusion there, and I'll take responsibility for the question. In regards to the threshold showing about the conflict, so the threshold showing of a conflict of interest under Rule 1.7. So the AG's it seems to follow after in time to see if there's a conflict initially. So in regards to establishing that, defense, and I don't wish to speak for you, but my understanding is you wish to call witnesses to put that evidence on.
Then I misunderstood the court's question. I don't think we need to take testimony in order for this court to make a finding on under 1.7 that conflict-free counsel should represent the state in this motion. I am not suggesting, and I didn't mean to, that there should be two hearings. That's not what, so if I misunderstood the court's question, I thought the court was saying, do we even need an evidentiary hearing on your motion to disqualify? Isn't it enough for the court to just read the papers? But that was not, was that your question?
Well, and I'll take full responsibility on my question. That was really the push on it, because my understanding is that determination needs to be made based off what you told us in the beginning, that a showing of a conflict of interest, there has to be a very good possibility of a conflict, or showing of a conflict is the very first step before we go down the further road of addressing the AG's office. And so I was alluding to, based off that, does that require an evidentiary hearing from your perspective?
I don't think that it requires an evidentiary hearing, but I don't want to predict or make assumptions about the court's view. I believe that the Utah County Attorney's disclosure to us on October 20th of this situation and our assessment that it creates a conflict of interest is not frivolous. It's not taken for the purposes of delay or tactics. It's a real potential conflict I don't know what the threshold showing is that permits or requires the court to exercise its authority under what is now in juxtaposition to the Utah legislature changes its code so often, like we have to figure out all the new code numbers, but it's now section 17-68-304, which gives the court the authority to appoint the Attorney General in this situation for this purpose, 17-68-304, as opposed to the code section cited in Jimenez. The law is the same, but the code sections have changed. But what I'm saying is, I don't want to predict or gamble with what showing this court thinks is necessary in order to appropriately exercise its discretion to make that referral. And so if the court says, I need more, then we should have an evidentiary hearing, because the important thing is to get it right, not for me to bargain on whether our papers show enough. The only thing that we know that we can show in our papers is what we were told and what we were given. And we were given some text messaging between family members and maybe some other people. I mean, the court has that, it's an exhibit. That's all we really have. And so I don't want to just say, oh yeah, there's enough there, and then have the court say, no, there isn't. Because it may be that the court wants to take some permit us to take some preliminary testimony in order to make that decision. But what I really think, instead of starting an evidentiary hearing on a motion to determine if there should be a referral, I think that there's a sufficient showing that there should be a referral by this court because of 1.7, under the court's authority under Utah Code Section 17-68-304, before we even begin to take testimony. I mean, the fact that Mr. Gray is going to be the first witness we call already, and that the state hasn't moved to quash because it's a frivolous subpoena, or it doesn't have, there's no basis in the factual predicate to examine Mr. Gray about these things, suggests that there's a problem here. That Mr. Gray's office is representing Mr. Gray while also trying to represent the state. And that's an inherent problem. And I understand it's a thorny question. It's what's the showing that's necessary, and does the court have discretion, or is the court compelled to? Is the court going to commit error if it doesn't? That's why I think that maybe some thoughtful briefing is an appropriate thing to do. Before we start an evidentiary hearing and then realize that we got off on the wrong foot, because there should be somebody else seated at counsel table when two members of the state's attorney's office, who are members of the prosecution team, are two of the 4 or 5 witnesses in this hearing. So I'm not trying to dance around the court's question. What I'm really saying is, I don't know that we can be stuck with only being able to give a court a showing based on the evidence we've been given, when all we've been given is a memo that says, this person was there, we don't think it's a problem, they were 85 feet away when Mr. Kirk was killed.
And so, and I appreciate what you're saying, counsel, but what I'm trying to determine is, in your regard, in your understanding, I want to address this, the sufficiency of the showing. Is it your request for an evidentiary hearing for you to present to the court enough evidence for the court to make that determination, or something else?
If the court doesn't believe that the papers themselves sufficiently demonstrate that for purposes of the motion to disqualify, the state should be represented by somebody else, then the answer is yes, we want to have an evidentiary hearing up until the point where the court reaches that conclusion. Because that would be the only way for us to satisfy whatever showing the court deems necessary. So I'm not going to waive an evidentiary hearing if the court's saying, well, I don't think you have enough evidence here, obviously the answer is yes. What I'm really just saying is, I think that based on the papers, the court can say, yeah, this is a significant problem in a serious case that has really, really serious consequences for Mr. Robinson, for the people of the state of Utah, for the victim's family, and we should do this carefully and correctly. And I think the way to do that is to have the Attorney General of Utah designate somebody in their office to represent the county for this limited purpose until the court determines the scope of the conflict. We think the conflict requires disqualification from the case, but ultimately, obviously, that's going to be a judicial determination.
All right. Anything further from the state before the court makes its ruling on this issue?
I just want to clarify, you're talking about the need for an evidentiary hearing in order to determine whether or not the states, that the county attorney's office can handle the motion to disqualify?
No, I'm determining just an initial showing of a conflict that exists here. Like
Well, for what purpose? To disqualify the office or to have the Attorney General's office step in and handle the disqualification motion?
to disqualify the office.
Can I take a crack at it?
If you wouldn't mind, Mr. Gray, just stepping to the lectern, just so the record picks you up. Sometimes these microphones are a little long.
If I could take a crack at it. Basically, I think what you're saying is kind of like a Frank's hearing where you have to allege sufficient facts so that based on those facts, if the court takes that as true, then you would need whether or not there would be a legal basis to conflict it out or find a conflict, right? And so if they don't make that showing, then the court can rule straightway. But if they do make that showing, if what's alleged is true, then we go to an evidentiary hearing. Is that?
Mostly, it's the initial showing of a conflict, and what happens after that will be determined because they're bringing this up for the first time today.
Basically, like a prima facie showing initially. Is that what you're
Essentially.
saying? Yeah. Okay. I think that's. Yeah.
All right.
I'll let you.
No, I appreciate your clarification. Mr. McBride.
Nothing else.
All right, it's the court's, and I've read the briefing by all parties and listened to the argument today, and I don't believe a sufficient showing has been made for the court just relying upon the briefing itself. And so I can't make that finding based off, well, I would find that that threshold showing hasn't been met based off the briefing. And turning to Mr. Novak, based off that finding of the court, what is your position?
Our view is that if the court has concluded that the briefing does not yet rise to the level of proof that the court should at this time make a referral, then the court should begin to take evidence. And there may be a moment where the court says, okay, I've heard enough, now I'm ready to make a referral, and we're going to stop and pause and wait for the Attorney General to engage, and then we'll have to see where that goes, but it may be that we have to finish the evidentiary hearing. But, and I think all of us can attempt to prioritize the portions of our examination so that the court can make that finding as early as possible. I'm just trying to avoid doing the hearing twice.
I understand.
Because right now, it's our view, the state is not being represented by the attorneys who should be representing it. And so if the state's going to come in later and say, well, we want to redo the evidentiary hearing because the state wasn't represented by the right parties, I mean, or by the right lawyers, that's something that we would want to avoid. We want to do this once out of a courtesy to the court and to a couple of the witnesses.
No, I appreciate that. And can this be accomplished by proffer?
I don't know what the witnesses are going to say because they've only given us very limited information. The state elected to give us information in their briefing, some of which is, like I said a few times now, is not sworn by affidavit or declaration. It's in the nature of argument. I mean, there are portions of Mr. Gray's brief, he signed it, where he makes many, many assertions of fact in the course of arguing the legal issues. And none of that is sworn. And I mean, I'm sure that, and I think, so I don't think there can be a proffer because I don't know what the proffer is. I know that I have a lot of questions about things that we were not, that the court was not told about in the briefing and the affidavits. So the answer respectfully is no, it can't be done by proffer.
All right. And which witnesses are you intending to call today? And I understand you're saying you wish to just put on enough and focus on the key issues, but just if I were to grant, I'm just trying to understand the scope.
Well, I think Mr. Gray is the first witness. The second witness.
Your Honor, who may approach?
Yes. Parties to the bench, please.
Okay.
Thank you, counsel. In regards to the question of what witnesses do you anticipate calling?
Mr. Gray, I'm going to get his title wrong, but Mr. Christensen is an investigator with the county attorney's office. The prosecutor, who we believe is conflicted off, and their offspring.
Okay. All right. Any input from the state at this point?
No.
All right. I'm assuming the next portion that we need to address is your motion in regards to the hearing itself, the evidentiary hearing, whether it's closed or open. Correct?
Is the court looking over my shoulder at
No, I'm
media
looking at
counsel?
no, you.
Okay.
Sorry, there is someone behind you, but I was trying to look at you. That monitor's in the way, but I appreciate the clarification.
When the county attorneys have informed us of this factual issue, and we told them that we thought that there was a disqualifying conflict, we had an agreement that we would file our motion privately, I think is the correct term,
Sure.
so that certain identities were protected. And that was at their request, and we've continued to accommodate that, and we have no problem with that. So we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so. And it is, and Mr. McBride has verbalized this very well in conversations and in council, the record is going to be very, very muddy if we can't have examinations that use names and identities. It's just going to be super, super awkward. And so that's why we are fine with the hearing being closed, which I think it's fair to say we view as an appropriate deference to the requests of the county attorneys.
All right. To the state.
Given the extreme publicity and the issues that surround this case, we would ask that this portion of the hearing be closed. We've had communications with counsel for the media. We believe that they agree to that after taking a balancing test of the public's right to know and the right to an open proceeding and the privacy interests at issue.
All right. One of my concerns that I have, and is there any other parties weighing in?
I think there may be, Your Honor, both by
Your Honor.
WebEx and here in person.
All right. Well,
Your Honor, this is Jeff Hunt. Can you hear me?
I sure can, Mr. Hunt. Thank you.
Your Honor, thank you for the accommodation and courtesy to allow us to appear remotely. With me is my colleague, David Ryman. We represent the Deseret News, KSL, KUTV, and other news media. We would like to speak briefly to the closure issue, if that's okay.
All right. I'll hear from you.
We did meet and confer with counsel for the state and counsel for the defendant concerning closure. And counsel has explained that they believe it would be impossible to conduct this hearing or even portions of it in open court without causing prejudice to the privacy and personal safety interests of the family member witness involved. They've told us they believe it would not be feasible or practicable to approach this on a witness-by-witness basis or an issue-by-issue basis because they believe the names of the prosecutor and the family member would be used throughout the examination of witnesses. So we have no reason to doubt the statements and representations of counsel, and in reliance on those would not be objecting to closure of the evidentiary hearing on the disqualification and the referral issues unless the court has a different view and believes that we could parse this on a witness-by-witness or an issue-by-issue basis. That said, Your Honor, we understand that counsel for the state and the defendant have agreed to review a transcript of any evidentiary hearing and make limited and appropriate redactions so that a public version of the transcript could be released. And with that, there are just a couple other brief points I'd like to make. First, we think that this should be the rare exception to conducting these proceedings in open court. There's a strong constitutional presumption of open and public court proceedings, and of course, enormous public interest in this particular case. That openness and transparency is an institutional value that serves this court, the participants, and the public well. The facts and circumstances of this particular motion, given the fact that it concerns a family relationship of the prosecutor, makes it a very extraordinary and unique situation that we feel, given the representations made, can justify the closure. Although we do believe in most cases just the fact that a motion implicates a witness will not be grounds for closure. Second, we just wanted to get on the record that we believe that release of a transcript is not an adequate substitute for the ability of the public and the press to attend and view the proceedings themselves. For this particular evidentiary hearing, that may be the only practical mechanism for the public to obtain some information about the case. But again, we would expect this would be the exception and not become a regular practice. And finally, Your Honor, it's our position that any oral argument on the disqualification motion or the referral motion should be conducted in a public hearing. As this hearing itself has shown, a lot can be done and argued without disclosing the names of family members or the witness at issue and jeopardizing those interests. Counsel can refrain from identifying the prosecutor or family member to protect the asserted privacy interests. And we have experienced counsel. They could be mindful of that issue during oral argument, and it's not unduly burdensome for them to take those steps. And any burden would be greatly outweighed by the public interest in learning more about the motion and having at least an open argument. So we do believe that the argument, and I understand the argument will be made at a later date, not today, but that should be done in open court. That's all I have, Your Honor.
Thank you, Mr. Hunt. Anything further from the parties?
Your Honor, as to the oral argument, it is our request that it be closed, and the reason why is that we're not perfect. Names slip. It's happened in trials. It's happened in arguments before, and I'm concerned of the risk that that could have if one of the parties, one of the attorneys, were to slip and identify those who ought to be protected. With that said, a fallback position could be not live streaming the event and requiring any redaction should an inadvertent mention of a name be made.
Thank you. Counsel, one of my biggest concerns is I have to make findings of fact that are very specific. I can't redact my findings when I issue an order. And I will have to cite to the relevant facts. And quite honestly, the name of the prosecutor is a relevant fact. I can't simply glaze over that and make an assertion. It's important because it relates to various factors that you may address, and which has been brought up in briefing. And so this court is going to deny the request to close the hearing as it relates to, and I will take this motion witness by witness. I understand that there may be a witness that this is applicable to, and the court will entertain that, but because this court has to make findings and has to cite to the facts, I need to be able to do that. And since I'm going to do that anyway, which I will, I'd rather address it in an open court. And again, I will entertain any motions, witness by witness, that are going to be called and be respectful of that. But going to Mr. McBride's point, you both have that duty. It's in regards to how you present, and if you're talking about a name that needs to be protected, that's on you, on how you speak. I can't. It seems inappropriate to create a safeguard to prevent you from making a mistake on accidentally saying a name. That I don't believe that would be a proper reason to close the hearing just for that. And I understand the pressure, counsel. I know it's difficult, but I cannot accept that as a reason to close the entire proceedings for the evidentiary hearing portion. But again, as the witnesses are called, I will entertain the motion whether to close the hearing per witness, and we will address it as we go. Mr. Novak.
Yes, Your Honor.
With that, how would we like to proceed? Well, first, is there any clarification needed on this court's ruling as we're proceeding into the evidentiary hearing?
I just want to clarify. Are you going to entertain motions to close at the outset of every witness? Is that what I understand?
If the motion is made, yes.
Okay, thank you.
May we have a moment?
Yes.